Hey, good morning, everybody. Welcome to Law and Legitimacy. It's the first Friday of the new year. I was going to call it Effed Up Friday, but I figured some of you might have your kids in the car and they'd want to know what Effed Up meant. So now turn to mommy and daddy and say, Mommy and Daddy, what does Effed Up mean? And how come that man said, if you see K, tell her I said hello? Who's K? Welcome. Welcome. Hey, so, you know, somebody out there in our listenership, do us a solid and send us a note or call us or do something and explain the following. Why does anybody really care about Jeff Epstein and Fantasy Island or whatever it's called? I mean, this segment is going to cost me some goodwill with a good friend, Mike Cernovich. Mike is a longtime friend. He invited me to podcast with him back way back in 2003 when he started Crime and Federalism. This was before he became an alt-right thing, and I've watched his emergence on in social media with a combination of envy and regret and sorrow. The envy was, wow, I could have been a contender. Look at Mike go. He's getting interviewed in the New Yorker and the New York Times, 60 Minutes, all that jazz. Me, I'm just scribbling away, screaming on behalf of clients still. That's the envy. The regret is um, maybe I'm missing something. Maybe there's a way to boost my profile. The sorrow is it can't be the way Mike did it. Pizzagate, really? I mean, Mike was one of the progenitors of the whole Pizzagate Comet Pizza thing. Democrats are peddling sex trafficking children out of the basement of a pizzeria. A, there was no basement in the pizzeria. B, there's no evidence that they did it. And to just kind of jump on the sex bandwagon and say, "Ooh, they're child sex traffickers," that's irresponsible. And I think that same impulse to get clicks for clickbait, the lust for fame, supports a lot of this complaining and bitching and moaning about Jeff Epstein. Now, what am I talking about? Sex trafficking. Ghislaine Maxwell was, after all, convicted as girlfriend. And now, the courts are getting ready to release documents relating to that case. And we're going to learn the identity of powerful people who sex traffic children. And you're starting to think, what are they doing to those 6-year-olds, those poor 5-year-old kids? Johnny should be in kindergarten coloring, not doing whatever a sex trafficker does to a child. But here's what I suspect happened. I suspect that a lot of almost all, and this is what I want to find out from you, listeners and viewers, were there any real children involved in this enterprise, or were they all teenagers, post puberty, on the cusp of puberty, dealing with puberty? And let me give you a quick history lesson that will inform my perspective on this. At the time of the founding of the Republic and well until the 19th century, the age of consent for sexual relations ranged from 9 years old in Maryland to an average of 12 in the other colonies. In other words, as a matter of law, if you were 13 years old in the United States and you had an itch that only a libidinal enterprise could scratch, you were free to do it. And if somebody helped you relieve that itch, they weren't a criminal. What changed? What changed was the law, not human nature, not our capacity, not our desires, not who we are. The law changed. And why did it change? The same people who brought us prohibition brought us statutory rape. And what do I mean by that? In the 19th century, as industrialization took root in the Northeast in the United States, many young people were leaving family farms throughout the country to live in cities, to seek better opportunities. It was, I think, early in the 20th century that we reached a tipping point where we had more urban dwellers in the United States than people dwelling on farms. Social reformers decided that there were going to be an awful lot of young women unsupervised in these urban hellholes. And they wanted to make sure that old men like Mike, and not me, but old men wouldn't prey upon them. So they sought statutory changes to raise the age of consent to 16 and in some cases even older. And so the law basically said at that point that even if a 15-year-old wanted to have sex, she couldn't without breaking the law. And so the consequence is that you've got people coping with their desires, learning about their sexuality, and we are sexual beings. If you doubt it, take a look at the mirror and ask yourself the following question: how did I get here? And unless you were delivered by ET on the back end of some interplanetary express from a universe we've not yet discovered, odds are you're here because somebody did the wow
Stork.
thing.
Yeah,
Yeah,
stork.
yeah. And so let's not kid ourselves about sex. Now, I'm not approving of Bill Clinton or others getting back rubs from nubile 14 and 15-year-olds. But on the other hand, I'm not going to deify the nubile 14 and 15-year-olds and claim that they were somehow victims in this case, because as any young person who's engaged in backseat wrestling, a little ditty about Jack and Diane, two American kids doing the best they can, knows when your time comes to inhabit your body in a new way, you wrestle with what to do with it. And I mean, there are probably many people listening to this stream, perhaps a few contributing to it, who lost their virginity before it was lawful to do so. Does that make us criminals for having succumbed to a natural impulse? I don't know. Does it certainly misguided youths? So, I know a guy who, at the age of 15, lost his virginity to an 18-year-old woman. Did he regard the 18-year-old woman as a criminal? Hell no. He thought she was the fourth person of the Trinity. So don't talk to me about Jeff Epstein. Don't talk to me about sex trafficking. Don't tell me about all the corrupt old men who were abusing children in this context. Talk to me about discrete assignations. Talk to me about how old the person was with whom the man or woman cavorted. Talk to me about the state of mind of the person with whom they cavorted. Talk to me about whether that person did, in fact, consent in exchange for consideration, maybe money, maybe access to fame, maybe access to power, maybe access to the social casting couch. Talk to me about those cases. And my hunch, although I don't know this, but my hunch is when that's done, what you're going to see is not child sex trafficking. What you're going to see is not child abuse. What you're going to see is adolescents taking advantage of older men, and older men taking advantage of adolescents, and doing what all of us have done from time to time, losing our head over our carnal desires. That's the very nature of sin. You've heard it here said before: sin is love of the wrong thing. And what's one of the seven deadly sins? Lust. Okay, they sinned. Go forward, sin no more. But making a national preoccupation of Jeff Epstein and referring to this as evidence of some sort of high-powered sex trafficking scandal that reveals that just what exactly? That the rich and famous are corrupt? Well, gee, there's a news flash. I mean, it seems to me like we're getting ready to do Pizzagate all over again. And I don't want to have any part of it. And I want to kind of squelch it unless I'm wrong. And so here's the Epstein challenge: give me factual examples of child sex trafficking in the Epstein enterprise, and I'll change my opinion. But right now, based on what I've read, what I see are precocious young teenagers and old men doing what's been done forever, and that is having sex. And it's just sex, stupid. It's really not that interesting.
Well,
What do you got on the line here?
yeah, in defense of Cernovich, and both are friends of the podcast. They both appeared. Mark
Oh, I
Randazza.
like these guys. Don't get me wrong. I'm not trying to disrespect them.
So if anybody wants to understand the origins of the Epstein files, I do encourage you to go, and this is a newsletter that Cernovich published this week. He has a newsletter, Norm, that he has titled "The Other Side of Fear." I just subscribed on a personal email, but I was already subscribed, which is how I knew it was out there to begin with. But the title of this is "The Epstein Files Are a Continuation of the Cover-Up." So in Cernovich's opinion, and to his credit, he retained Mark Randazza in 2017 to unseal the records in a freedom of the press case, and this is his origins within that realm. His position on this is that this entire part of the case, and I hope I'm paraphrasing accurately, but it says it pretty clearly there. The Epstein files are a continuation of the cover up. Is that this has already all been mopped up, and that whatever is being leaked out right now, creating a media frenzy, having people
I
ask
smell. I
if Jimmy
smell.
Kimmel was on the list and all this other stuff.
It's cold pizza. It's
Is
cold. This is just Pizzagate hysteria all over again.
But
There
ultimately,
was
I think
deep,
the
dark
layered
sex
issue here, Norm.
going on, and now we're not going to find out about it, and the world is corrupt. And I mean, this is just moralism. This is misguided moralism. This is not worthy of public debate, Mike.
But here's what I wanted to. Epstein was an asset of the FBI. what his exact relation remains sealed. And that's his position on all of this, right? So I do encourage any of you who are looking to get some sort of foundational understanding of what the case is, how it originated, and any of the procedural timeline and chronology there, to go to at Marco Randazza on X, go to at Cernovich on X, subscribe to the Other Side of Fear, engage with those two gentlemen on this issue. Mark Randazza appeared on Fox earlier this week live to discuss the origins of the case as in his involvement, his being retained there, and ultimately, I think that there what you're parsing, Norm, is really important. But I think most people are interested in Epstein's relationship to intelligence assets or to the intelligence agencies in the United States and this, I guess, patterned blackmail scheme on domestic assets as well as foreign assets and other governments.
We're going to have to get Randazza and or Cernovich on to discuss this because, as far as I'm concerned, this is beneath both of them.
Well, we will. We
And
will. We'll
I
definitely get
understand.
Randazza, maybe
I
Sir.
understand tabloid journalism, and I understand the instinct to stir a scandal. And it's entirely likely that Epstein and others were from time to time assets of the FBI, which maintains a robust use of confidential human sources to gain leverage and insight into all manner of things. But when
Well, there
I'm
is a
looking
deep
at it,
thirst, Norm. Norm, there's a deep thirst for people like Bill Clinton to meet some sort of justice, right? I think we must understand that the populist time in which we live, people are they have an insatiable hunger to
people are
see these.
angry, but I'm not sure that's a thirst
But
for
so
justice.
this
As
is that.
angry
This is a
people look for
projection.
scapegoats, and
I
scapegoats are
understand. That's what I'm
that are
saying.
tossed onto the screen for just bloodlust. And are we really getting anything in exchange for all of this other than a misplaced sense of satisfaction or
No,
sheer
I don't think that
brilliance?
we're getting even a misplaced sense of satisfaction, to be honest with you. I think that this is largely empty calories,
Yeah,
intellectual,
me too.
like empty intellectual calories as it's being presented to the masses right now. You can't make heads or tails of who's involved, what their involvement was, blah blah blah. But every other socio-cultural rage-oriented outlet is going to scream from the rooftops that this is a huge deal. And I agree with you to the extent that this seems um, lukewarm at best, but there are facts in history that are easily within one's custody if they just go to these two sources and read for themselves. And I don't have a lot
I
to
hear
say
you, but
about
I'm not going to spend a whole lot of time worrying about flying saucers in the 1950s either. Hey, let's move on to
or about
jalapeno
8 to
jack.
10-foot creatures in Miami either. Isn't that right? High society. Anyway,
Let's talk about Jalapeno Jack and Donald Trump. Lots going on in Washington this week. Why, I'm starting to think that Donald Trump's legal team, and this surprises me to say, might be playing chess while Jalapeno Jack is playing checkers. As you know, the Chutkan case, the obstruction of justice case against Trump for his January 6th related conduct, has been put on ice while the District of Columbia Circuit Court of Appeals hears argument about the scope of immunity, presidential immunity for his speech and conduct while president, as related to the J6 prosecution. I believe argument is set on those appeals on January 9th, and there will be a decision shortly thereafter. When that appeal was taken, Judge Chutkan decided to, quote, hold in abeyance, end quote, the discovery and court and compliance with court orders in that case until the appellate court could rule. That hasn't stopped Jalapeno Jack from filing motions, and that hasn't stopped Jalapeno Jack from giving more discovery to the Trump team. And so the Trump team just this week, I think yesterday, moved to hold Jack Smith in contempt for violating a court order. The contention is that, much as in a bankruptcy case where the mere filing of bankruptcy operates as a stay on what others can do in related litigation. In this case, holding the case in abeyance operates as the functional equivalent of a stay. Chutkan's not going to hold Smith in contempt. It's not a stay. The reason for a bankruptcy stay is when a debtor goes into bankruptcy, he's doing so either to liquidate or to reorganize. And in either case, he's in bankruptcy to reach compromises with his creditors. And the reason for the stay is so that the bankrupt won't waste assets to the detriment of creditors. There's nothing like that going on in the Smith Trump case. But last week, or maybe the week before, Smith filed a very interesting motion, a motion in limine. That really tells you what the government's worried about in this case. And candidly, the motion drives me nuts. Now you're sitting there thinking, motion in limine. Yeah, I can understand being in Toledo. I can understand even being in Jeff Epstein's airplane. But where in the hell is limine? Motion in limine means a motion at the threshold, at the doorstep of a proceeding. It's a motion filed by a party to shape what it is that a jury can and can't hear. And so, what we learn in the government's motion in limine is what it's worried about, what it's worried that Donald Trump will do to the government's case in the jury's presence. And Jack is looking for an order from the court to prevent Trump from doing it. Now, before we discuss this, look at the caption to the case. It's at the top of the screen. What does it say? It says United States of America versus Donald Trump. That right? Then it's got a docket number and everything. So this is a two-party dispute. The
Which,
United
by the
States.
way, if you want, I can download this and maybe I'll send a link to the PDF in our first newsletter. But again, this is one of those things that I really like about what we're able to do, Norm, is point people to the primary source documents that all other media outlets use as the resources for their stories and the downstream sort of iterations of what's actually going on. But just to recap, a motion in limine is made by a party to a proceeding to preclude the other side from introducing certain types of things into evidence for consideration in a trial. Is that a fair
Or even from arguing it in the jury's presence rather. It's the so-called pink elephant problem. Isn't it true, sir, that you didn't ride on the city bus to the bank robbery? You rode in on a pink elephant. Objection, irrelevant, sustained. You are to disregard the testimony about a pink elephant. What's everybody thinking about? The pink elephant. And so small little questions can reframe a case. And so a shrewd litigant says, I want my best shot at winning. And my best shot at winning means I frame the case and I prevent my adversary from introducing themes that might distract the jury. So a motion in limine says before the proceedings begin, the court's going to rule that certain things can't even be raised in the jury's presence. They have to be done outside the jury's presence. And so, but I say look at the caption because I think Jack will get a lot of the relief that he wants. Jalapeno Jack will get a lot of the relief he wants. I don't think he should, however. The caption is United States of America versus Donald Trump. Now let's deconstruct what that means. This is a two-party action. It's the United States of America versus Donald Trump. You'll never see the United States of America in that courtroom, the party. And the reason you won't is, as a strict matter of fact, the United States of America is a legal fiction. It doesn't exist. You live in it. You pay taxes to it. You interact with it in any number of ways, but you never see it. You never feel it. You never touch it. And that's because it's a legal fiction.
It's the pronoun problem. You can also think about this as, the Arizona Diamondbacks do not exist, right? You're not going to find an Arizona Diamondback in the airport, right? You will find a player who plays for the organization, right? And so again, going back to yesterday, we have a set of governing documents and we have a certain acquiescence to be governed. And those governing documents don't even say explicitly that they are governing. However,
no, that's true.
we abide them.
But here we are. And so the United States of America is a party in this case, and it's a party that acts through its agents. And its agents are prosecutors and other governmental officials. Now, what'll happen, one of the things that Smith wants to do is it wants to keep and this is on page 4, it should prohibit the defendant from introducing evidence, making arguments, or framing questions to advance a theory of selective or vindictive prosecution or otherwise properly object politics into the trial. Let me violate the rule I announced earlier and use a piece of profanity. Give me a fucking break, Jacko. I mean, this is the defense. It is never collateral on Sixth Amendment grounds. A party's motives are never collateral in bringing an act in when they testify.
This is like appealing to a referee in the middle of a game. You should, or before a game, you shouldn't let them shoot from behind the 3-point line. Okay, they're going to try that, but they shouldn't be allowed to shoot from behind the 3-point line, Mr. Ref.
Now, the Smith will argue that, and I've heard he will argue, look, Judge, and I've heard many judges say this. I even heard it during the Proud Boys case. The government's not on trial here, Mr. Pattis. I'm like, I beg your pardon? It's the United States of America that brought this case. They decided to walk into this courtroom, and when they put an agent on the stand, that agent is on trial, just like my client is, because it's the other side of the caption. Now, Smith and company and the court will likely conclude that, hey, look, what the trial is about is whether the government can prove its allegations against Donald Trump. And all evidence is material and relevant that tends to prove or disprove that Trump is guilty of the crime charged. That means that he engaged in the proscribed conduct that the indictment describes. The court will then say that the motive of government agents testifying on behalf of the United States is immaterial. It doesn't matter and not relevant. It sheds no light on whether Trump engaged in those discrete acts of conduct. The counter argument, which I think is better as a matter of fact and as a matter of law, is that the agents have interests in the outcome, and they wouldn't be testifying. And their interest isn't just to see that justice is done. They want to get a conviction. They want to get a conviction for reasons. Those reasons include their belief that he violated the law. And what inspires those beliefs is in part their political view of his conduct and the conduct that he engaged in at that point. However, I think Chutkan won't rule on this motion right away because it's not technically before the court as discovery and motion practice has been stayed. The court should also prohibit on page 6, the caption reads, the defense from trying to baselessly inject politics in the trial in the name of impeaching the investigation. Give me a break. This is one of the most political prosecutions that has
Well, and
taken
I'm gonna
place in
go right
United
back up to
States
the beginning
history.
here. I'm gonna go back up to the beginning because this is in their intro paragraph. They say, through public statements, filings, and argument and hearings before the court, the defense has attempted to inject into this case partisan political attacks and irrelevant prejudicial issues that have no place in a jury trial, right? And so this is where you're getting on page 6, but they tried to tee that up in the introduction.
Then on page 3, there's a blockbuster issue, which I hope Trump's lawyers have the savvy to really lean in on. The court should prohibit the defendant from arguing to the jury any legal issues properly reserved for the court. Basically, this is an argument against jury nullification, and it cites an 1895 case called Sparf versus United States. You legal nerds out there will look it up today. It's at 156 U.S. Reporter 51. Sparf is a case I know well. It is the
Oh, did you say
only time.
page 3?
No, page whatever I said, it's actually on page 7,
Okay.
toward the bottom. I may have said 3. Who knows?
Got it.
I may have said Jeff Epstein had sex with as a child sex trafficker. Who knows? So jury nullification is, a jury's right to decide facts and law. The United States Supreme Court has only once in its history issued a decision involving jury nullification, and that is the Sparf decision. In the Sparf case was a maritime homicide case, that is a death at high seas case, and it wasn't uncommon, unfortunately, as a matter of fact, in the 19th century and earlier, for a ship to leave with 9 people and come back with 8. And the question would be, what became of the 9th? And often there may have been a dispute at the high seas, and perhaps somebody was tossed overboard. And if nobody was going to talk about it, okay, you got a problem there. People don't just disappear, but you've got to prove a homicide. And you've got to prove the manner and means of death if you're going to win a murder conviction. And so in the Sparf case, individuals were charged with murder. They were believed to have killed one of their shipmates. It may have been the captain. I simply don't recall whether it was a mutiny at the high seas. And at trial, their defense lawyers tried to introduce what are known as lesser included offenses. We've talked about this before: homicide, taking of a man or woman's life, a person's life. It comes in various grades. Murder, that is the specific intent to cause death; manslaughter, engaging in reckless conduct or being extremely indifferent to whether a person lives or dies, and engaging in conduct that results in death; criminally negligent homicide, engaging in conduct that is a gross deviation from the standard of care we expect of reasonable people. The differences between these forms of homicide are in terms of the culpability or blameworthiness of the defendant, and the consequences in terms of sentencing can be vast. A capital felony for regimes that recognize it could result in your execution. An ordinary murder, a life sentence; manslaughter, decades behind bars; criminally negligent homicide is a misdemeanor, at least in Connecticut right now. You get up to a year. So the lawyers wanted to put before the jury these lesser included offenses. And all the court said in Sparf is, and this is almost an exact quote because I've litigated this issue in several appellate courts around the country. All the United States Supreme Court said in Sparf is it is for the court to decide the law and the jury to decide the facts. And in order for a defendant to get or place before the jury lesser included offenses, there have to be sufficient facts to support that charge. And in this case, there isn't. That's it. Now, from that slender reed has been built a house of jury nullification doctrines that basically say you cannot ask as a litigant juries to disregard the law. You can't ask jurors to sit in judgment of the government and whether it should have brought those charges at all. A jury nullification argument in the Trump case would be, look at this prosecution. It stinks. This is a Justice Department that wanted to silence Mr. Trump right before the election in 2024, and it engaged in this conduct as its own form of election interference. This is a misapplication of the mission of the Justice Department. And you, ladies and gentlemen, we the people, we the sovereigns, so to speak, at least in argument under our constitutional system, need to send a message to the government. No, you made a mistake here. We don't care what you proved. The law shouldn't have been used this way. It's not the law that's an ass in this instance, to paraphrase Dickens. It's the government that's an ass. You just can't argue that in all but in federal courts because of United States versus
So,
Spark.
is it your position, Norm, that based on the way that they have paraphrased the holding in Sparf, that they have misquoted Sparf or miscited that?
No, I think that's the way. I think that
The jury's function is to apply the law as the judge determines it. Now, that
that's what Sparf says. But Sparf said it only in the limited context of whether the defendants were entitled to a lesser included offense. That's all. And so in law school you learn certain things. There's a holding, there's a ruling, and there's dicta. The ruling is, what question did the court decide it? You can either have 3 widgets or 4. The holding is the legal principle that supported that, and it lives beyond the ruling. It can be used to apply. It can be applied and used in other similarly situated cases. Um,
precedent.
Precedent, stare decisis. Yes. And then dicta is language that the court uses that wasn't necessary to reach its conclusion, but helped explain its conclusion, and it sheds light on how the court regarded the issue before it. I suggest to you, ladies and gentlemen, that Sparf v. United States and jury nullification is a monster that grew up from a piece of ill-digested dicta, and it needs to be taken on and dismantled in front of the United States Supreme Court. And Trump and his lawyers have the perfect opportunity to do so in this case, if they will but double down on Sparf versus United States. And because I'm a patriotic American, I refer them to the case in the United States Second Circuit Court of Appeals of United States of America versus Yehudi, Yehudi Manzano, Manzano. That's the highest I've been ever able to get this issue to an appellate court, and I lost 2-1. One judge, Judge Parker, agreed with me that there was a right to argue jury nullification in certain cases, but 2 of his colleagues disagreed. We couldn't get the Supreme Court to hear it. But Donald Trump's got a free pass to the United States Supreme Court right now. The world is watching. The stakes couldn't be higher. And I'm urging the Trump legal team and those of you who listen to this podcast to get this to the Trump legal team to double down on United States versus Sparf and to double down on the jury nullification issue. It seems to me that if we're going to take popular sovereignty seriously, if we're not going to make a complete ass of the law, and we're going to say that when parties come to court, they subject their motives when they put witnesses on, all witnesses, including government agents, to a searing cross-examination because motive is never collateral, I would suggest that jury nullification in a case brought by the federal government or any government is something that ought to be within the jury's power. Juries should be able to decide not just whether the facts that a prosecutor alleges are true, but they should be able to decide whether the prosecutor should have been involved in pursuing that case at all. In other words, whether the prosecutor's decision to prosecute was unjust. If we, the people, can't decide that, and judges tell us it's beyond our province, it's beyond our ken, it's not something that we're entitled to do, we've lost a significant part of our sovereignty. And just as the Constitution is actually silent on the so-called state of nature and how it is that strangers become wedded to one another under the rule of law, it only refers to this by passing. The farther removed we come from our stories of origins, and the farther removed we get from stories about how strangers become friends to one another in a society, the farther we get from permitting the people to question the legitimacy of our institutions, the more diseased our society becomes, the more uneasy we become, and the harder it becomes to check power. There are other issues, obviously, in the motion in limine, but I see, I went on quite a rant there, Mike.
Well, no, it's
um,
beautiful. It's beautiful to me because I think that this rhymes or at least echoes some of the foundational issues in the January 6th prosecutions of the Proud Boys for seditious conspiracy, and it is, we've talked about jury nullification in the context there, and you've even parsed the merits of the issue of a state and district in which a defendant resides, and in this case, it's as if the prosecution, it is as if Jalapeno Jack and the Department of Justice are arguing at a layer above the foundational principles that you and I are talking about this morning, right? So I brought up what I have on the screen specifically to make the point that you just made much more eloquently than I ever could. But the quote is, as in any other case, the consequences that the defendant may face as a result of the criminal case against him are irrelevant to guilt or innocence and may not be considered by the jury. That may well be the settled precedent in general, but we have a baseline legitimacy issue of this case, right? There is a baseline and a foundational issue as to whether this case should have been pursued at all, which means that the politicization that this motion in limine is hoping to avoid from the defense, right? They're hoping that Donald Trump will not be able to present an adequate defense that points to the truth of the origins and the inspirations for this prosecution, so that the jury may not hear those. Those to me are two completely separate issues. This may live as a true recitation of existing precedent, but it could also be true that it's irrelevant for purposes of this discussion and whether a jury should be able to decide whether the case is even properly before them.
Well, I think in this case they should be able to decide that because I've said before that I believe the urgency that Jalapeno Jack presses this case with is reflected in a broader agenda to disqualify Trump under Section 3 of the 14th Amendment. Because to date, there has not been a judicial finding that Trump did anything that looks like insurrection. All we have is the House January 6th committee report, which begs the larger question. It avoids the hole in the middle of its donut, as we said yesterday. The Shannon case basically said that sentencing consequences are not for the jury, but even there our law is inconsistent. In death penalty cases, juries can consider the consequences. Why? Because the stakes are so much higher. What can be higher stakes litigation in the United States right now than litigation that would have the effect of disqualifying the choice of millions of Americans to become the next president of the United States? If ever there were a prosecution in which sentencing consequences should matter, it is this case. Shannon is a limited holding. Shannon arises from the following facts, if I'm not mistaken. I think it was a child pornography case where the defendant wanted to put on evidence of his diminished capacity, and the prosecution basically opened a door at some point by questioning the legitimacy or not the bona fides of that defense and opened the door to sentencing consequences. And they were permitted in the face of a general rule, otherwise never letting it happen.
We
And
have
anyhow,
a
look, we never.
question from Pete Atkinson. What do you think happens if Trump is barred from running for president?
Well, I think 2024 becomes the most momentous year in American political history since 1860 at that
I think
point.
Vivek is elected president.
Um, I don't know about that either. But I think that if you say to 10, 20, 30, 40, 50, 60 million Americans, the man you want to vote for president is unqualified and cannot appear on the ballot, you'll be saying to those people that your vote doesn't count and that your desires don't matter. And, Cass Sunstein wants to say that the best method for interpreting constitutional doctrine are democracy reinforcing principles. That would be the most profoundly democracy disenforcing decision possible. And I think it would be an absolute disaster for the republic. I think that the United States Supreme Court will go to great lengths this in the next few months to avoid deciding a case that keeps Trump off the ballot.
Yeah, and
Yesterday, Mike,
yesterday, Pete, we talked about there were betting odds presented in an article by The Hill, and if you weren't able to join us for the latter part of yesterday's stream, uh,
and where were you? I mean, come
yeah,
on.
as if you don't have anything else to do. But I'd go back to
Great
perhaps the
for
last 10
you.
to 12 minutes of yesterday's stream, and you'll see the article in The Hill that lists the various potential outcomes from a legal perspective on the petition to the Supreme Court in the Colorado Supreme Court ruling, removing him from the ballot. And the one that I chose, and I think Norm, you warmed to quite quickly
Oh
in the
yeah.
stream itself, was that we believe that they will grant cert, but they will not rush to even to issue an opinion on the case. It'll be
Yeah, no,
2020.
that's it. I think that's exactly right. So listen, we didn't get to our third issue today, and we've run out of time. But today is a conference day in the United States Supreme Court, and so before it today are dozens, if not hundreds, of petitions for certiorari. That is, requests that courts take up particular issues for review. And one of them I didn't even realize was before the court until Mike brought to my attention a story from the New York Sun, and it's the case of City of Grants Pass versus Gloria Johnson and others. It involves whether municipalities or state agencies can enforce laws against homelessness, meaning whether they can penalize people who encamp in public places. And the question presented is whether these laws violate the cruel and unusual
I mean,
punishment clause of the
amazing,
Eighth
right?
Amendment.
An
Isn't it?
amazing construction of the question. Does the enforcement of generally applicable laws regulating camping on public property constitute cruel and unusual punishment prohibited by the Eighth Amendment? I mean,
We're,
to
let's
also,
talk.
just fucking amazing to me.
No,
To
let's
answer the
talk
question.
about it tomorrow. I mean, it's when I saw that, I was scratching my head. Then I thought, oh, homelessness is a real problem, and I want to talk more about it tomorrow. But Mike, this attracted more than 2 dozen amicus briefs, friends of the court
20
briefs
states are
for the court.
involved. I think 20 or 12 or 13 municipalities, including Governor Gavin Newsom. He submitted an amicus brief, which, of course, if you've been following Gavin Newsom for any amount of time, you realize that he knows very little, if anything at all, about the homelessness problem. But he presents that as his sort of platform issue, and he's the man about homelessness. So, of course, he's not going to miss an opportunity to throw his hat into the ring to discuss irrelevant issues related to homelessness. And we'll also talk in stupid ass terms like about people experiencing houselessness or something like that, whatever it is. Uh, Bums not having a place to go that is funded by the public dollar is at the essence of this case. That's the essence
Maybe,
of this case.
maybe not. Maybe there's another way to look at it, and maybe it frames the problem of the one and the many in ways that are uncomfortable for us to behold as our borders seem to collapse under the tide of immigration. But let's talk about it tomorrow. Hey, Gold Store, Connecticut. Whose quote? I see your quote. A brilliant mind doesn't just know the law; it understands the heart behind it and the people it serves. Who's that come from? If it comes from you, let us know so that we can use it. It's a wonderful quote, and I think it's true. So tomorrow, barring some meteor collision with Earth or shocking disclosure involving Jeff Epstein, we'll
Today is
probably
Friday,
lead
Norm.
off.
So tomorrow we will be talking with, we'll be doing a long form interview. It will not be broadcast live, but we will be doing that with one and only Pete Atkinson. But on Monday,
That's
we will
the
be
problem with
discussing.
these short weeks. Yeah, we will get to Grants Pass and how and the question of what to do when a social problem confronts or when the Constitution has to grapple with a social problem that the framers didn't really have. And what do you do in that case? And what do we? Let's talk. Let's have some fun with the homelessness case. In the
We
meantime, folks, Mike's going to tell you how you can find us.
Okay.
Well, I mean, the law is fun. I mean, it's
The law
principle.
is fine. It's just a funny phrase. Let's have some fun with the homelessness case. Anyway, I've got up on the screen again, several of you, and I say several, that's an understatement. We've got people that are signing up to the newsletter. The first newsletter has not yet been published, but I do encourage you, go to lawpoddaily.com, put your email in the box there on the screen and subscribe to our forthcoming newsletter. Norm and I will be producing long form interviews, one per month. And like we said, we've got the theme of grace coming up this weekend. We will be sitting with Pete Atkinson to discuss that in a long
If
form.
ever there were a sinner in need of grace, it's that misbegotten piece
Well,
of
and Pete
ectoplasm
wants to
more
talk
than
to you
human.
about originalism and why you don't buy into it. So maybe that can be a part of what we discuss tomorrow, but we're not going to waste too much time with that. I definitely want to hear more of Pete than of you. No offense, Norm. We're also working on master outline for the Everyman's Con Law, which will be an 84 lesson course with PDF outlines to accompany those. And we're building out a what we're reading list as well as a sites we love list. And as we go forward, the newsletter is going to be your main vessel for reading any of the essays that we publish that are written. And this is all in addition to the daily live streams that we're doing. So nothing is going to change in terms of the Monday through Friday half hour live streams that we do here. What Norm and I are attempting to do is slow down in terms of chasing what's topical and be patient enough to discuss the issues in a little more detail as we did today with the motion in limine and as we did yesterday with the concept of governance. But then also spend time thinking about the inspiration that comes from the long form interviews and put those in the written word, and then also offer some sort of civics contribution to society. So one thing I was thinking about this morning, Norm and Julian, that's lawpoddaily.com. Lawpoddaily.com. One thing I was thinking about this morning is our audience and the demographics. For those of you who have children and or grandchildren who are, either in undergrad or graduating high school, or even in sort of a post schooling early career, please encourage them to spend a morning or two with us, or even just send them the lawpoddaily.com URL so that they can get a taste of what is going to be out there. My desire is that we continue to reach into the younger demographics, because part of the thesis of legitimacy is that there have to be people, and part of why I'm preoccupied with how successful Vivek has been of late communicating and articulating his message, is that people are hungry for purpose, and we want to reach young people while they are attempting to situate themselves in the world, and to help them contribute to the future of this great country that's given us the ability to do what we're doing. So I'll get off my soapbox here. Please go to lawpoddaily.com, subscribe to the newsletter. Julian, thank you for making me plug it again. And Norm, I'll see you tomorrow. But for
Yeah,
everybody
whenever you
else,
can.
we'll see you on Monday. Any parting words, or I'm just going to awkwardly
Yeah,
hit
what
the
time
mute
tomorrow?
button?
What time tomorrow?
We'll talk.
All
We'll
right,
talk.
we'll talk. We'll talk next week, folks. Be well, stay safe, and look out for Jeff Epstein's sex squad.
Lawpoddaily.com. See you tomorrow, Norm. Bye,
Bye.
everybody. Thank you.